Good day. I'm Daniela Ellerbeck, the legal advisor to Freedom of Religion South Africa, commonly known as 4SA. Joining me online is 4SA's Executive Director, Michael Swain. Michael, good day.
Hi, Daniela.
So today we're going to be discussing the meeting that 4SA and other stakeholders had with the Department of Justice on Monday, the 17th of October. This meeting was about the department's proposed changes to the Promotion of Equality and Prevention of Unfair Discrimination Act, commonly known as PEPUDA or the Equality Act. And these changes are taken together in the department's proposed amendment bill. Michael, perhaps you can give us some information on what this bill is and what the purpose of yesterday's meeting between the department and various stakeholders was.
Yeah, well, for those who aren't aware of this, PEPUDA, which you have given us the full name of, otherwise known as the Equality Act, has actually been in law since the year 2000, and it gives expression to the so-called Equality Clause, which is contained in Section 9 of the South African Constitution. It's important to remember that PEPUDA is a very important piece of legislation because it is literally second only to the Constitution in the hierarchy of South African law. And that means that effectively all other laws, all other regulations, all other policies have to be compliant and be in line with the provisions of PEPUDA. It's like the lens through which everything else is seen. So these amendments are, of course, deeply significant because they will be so far-reaching. And we looked at the original PEPUDA amendment bill, which we were discussing yesterday with the Deputy Minister and the Department of Justice. And we were really there to, first of all, hear their concerns or their feedback on the, I'm delighted to say, 100,000 plus submissions that were made to the Department of Justice, most of which were pushing back against the very far-reaching, very invasive provisions, particularly for the faith community, to not only hear their response to that, but also to have the opportunity to clarify and to reinforce the concerns that we share. So that was the essence of the meeting. And maybe, Daniel, you can now pick it up and tell us what were these proposed changes that PEPUDA Amendment Bill is going to bring, potentially, and what our concerns are in brief. And obviously, the next question would be, what do we propose doing about that?
Wow, 3 questions in one go. Okay, so the Promotion of Equality Prevention of Unfair Discrimination Act, PEPUDA, as you've said, this amendment bill proposes quite drastic changes to that act because it proposes, amongst other things, changing the definition of equality, changing the definition of discrimination, and very concerningly for private individuals and private bodies such as religious organizations or non-profit organizations and so forth, is the ability for the minister to make regulations and codes of conduct requiring these people and entities to promote the state's understanding of equality as redefined in the bill and to prevent the state's understanding of mere discrimination, not even unfair discrimination as redefined in the bill. So 4SA's concern is that the manner in which the bill seeks to achieve greater equality and less unfair discrimination will have the unintended consequence of overriding and trampling on, for example, the constitutional right to not be unfairly discriminated against because of grounds of conscience, religion, and belief, the right to religious freedom, freedom of expression, freedom of association, as well as the right of religious communities to practice their religion and to form religious associations, and to do so without the internal affairs being regulated and interfered with by the state. And the bill, amongst other things, proposes giving broad intrusive powers to the state, as I've mentioned, to prescribe to people and NGOs and religious organizations how to implement the state's understanding of equality and no unfair discrimination. And from a religious freedom point of view, Michael, if this bill was to be adopted in its current form, the state will effectively tell people of faith what to believe, including what they may or may not say and may or may not do as an expression of their beliefs, and how to run their internal affairs. This is state regulation of religion, which will result in the violation of various human rights and freedoms guaranteed by our Constitution, as well as undercutting the very well-established doctrine of entanglement in our law, which prevents the state from getting involved in doctrinal affairs. So,
Yeah, I think the other thing which really struck me about these amendments and the potential that they have to really be very invasive and very threatening is the broad definitions that it has. The definition of discrimination is basically any act or omission, whether intentional or not, directly or indirectly. In other words, it takes away any kind of objectivity. And then it's so broad. It says causes prejudice to or otherwise undermines the dignity of any other person. I mean, that pretty much catches anything and everything that you might say that somebody doesn't even like or that they feel is somehow discriminatory against them. And I think there's obviously a couple of problems there. The one is the extension or the expansion of liability under the Act that would kick in. So maybe you can just give us a couple of examples of how that might look.
Yes, so the bill proposes vast changes to the definitions of both equality and discrimination, as you've said. Equality, for example, is proposed to be redefined as equality in terms of impact, which goes much further than the right to equality as defined in our Constitution, which is limited to equality before the law, equal protection and benefit of the law, and the full and equal enjoyment of rights and freedoms, and substantive equality where needed. Now, obviously, substantive equality means, we will dedicate additional resources and help to make sure that everyone starts off at the same starting line. It is not equality of impact at all. So, and I mean, even there, the courts have said that just because everyone has the right to access to courts doesn't mean that every appeal application, for example, will have the same result. So that's an example of how the right to equality, everyone has the same right that they can exercise in public. That doesn't always lead to equal results.
Yeah, and I think also, if I remember and correctly, one of the problems that we've always had with PEPUDA, and we faced a couple of court cases in our time, is that once discrimination is established on one of the protected grounds, and there's a whole list of them that is way longer than those contained in the Constitution itself, then there's an automatic assumption that that discrimination, and as you said, it's now not just unfair discrimination, it's mere discrimination, which is even more concerning, but it is automatically deemed to be unfair. And then there's a test which then decides under PEPUDA whether or not that discrimination was indeed fair. But as we have established and as we have experienced, religious freedom in particular, and conscience and belief and thought and opinion, that is something which does not seem to be weighted correctly. It's very concerning that, in fact, on the contrary, it's often trumped by other rights. Can you tell us the problem with that particular test and what we for SA are proposing to do to fix it?
Yes. So, as you have said, the bill proposes drastic changes to discrimination and, for example, prohibits mere discrimination, not unfair discrimination, which is, if I can explain that with the use of a simple example for viewers, is we don't allow a 5-year-old to drive a car or to go vote, but we do allow an 18-year-old to do that. And that is discrimination. We're treating two people differently, and we're doing it because of their age, which is a prohibited ground in terms of the Act. So in terms of the Act, that would be deemed to be automatically unfair discrimination unless you can prove it fair using the Section 14 test. The bill proposes, amongst other things, instituting strict liability. So you will be held liable whether or not you intended to discriminate. Now, I want to point out that that makes the test for discrimination completely subjective, which is problematic because our courts have always said that it's the impact of the discrimination objectively assessed that one needs to look at to determine whether or not someone was actually discriminated against, not just how someone feels. It then goes further and also imposes vicarious liability on employers. So an employer will be held liable even though their employee might not have intended to discriminate at all. All of this is very problematic and not remedied by the current Section 14 test for fairness, because as you've said, this test has always had problems because it doesn't take into account whether or not the exercise of other fundamental rights, and we know that there's no hierarchy of rights in South Africa, whether or not the exercise of other fundamental rights which are main in to the context that the discrimination occurred in. So, for example, did we say that women can't be leaders in our religious organization because of our understanding of the Holy Scriptures and how we have chosen to live out our faith? And so was the exercise of our religious freedom, was the exercise of our right as a religious community to practice our religion and form religious associations, was that germane to saying that we are not going to have women as leaders in our organization? None of that is considered in the Section 14 test, and it should be. So that is something that 4SA proposed. And then, as you've also said, is we have seen this act misused and often weaponized to persecute people of faith and conservative convictions. So one of the other solutions that 4SA proposed is to include a clause that expressly prohibits unfair discrimination based on the ground of religion, belief, and conscience, which will go a far way into having an Equality Act that protects all equality grounds equally and allows everyone equal protection of the law as mandated by Section 9 of the Constitution.
Yeah, I think, talking of weaponizing, I think the other thing which was obviously very concerning for us in the original bill was the potential that legal aid, in other words, state funding, would be made available to people who wanted to bring actions under this very broad, expanded PEPUDA, which obviously has very grave implications, because often, and we've seen this in the past, as you know, an institution of state, perhaps it's the South African Human Rights Commission or the Commission for Gender Equality or one of those, will bring a case effectively on behalf of somebody who's bringing a complaint. But the person who is actually being complained against now is left to fund their own legal defense, which can be prohibitively expensive. And so one of the things that we said to the Deputy Minister was that we felt that because these matters are indeed constitutional matters, that there ought to be at the very least equal funding for either side in the event that that provision stays in at all. But maybe just to wrap up, Daniela, what would you say was the overall response of the Deputy Minister, and how did he receive the submissions that 4SA made and others?
So, Michael, it was very clear that as a result of the collective voice of the religious community, the Department of Justice took note to the religious freedom concerns. And the Deputy Minister gave his assurance that it was not the department's intention for the bill to interfere with religious autonomy or doctrinal interpretation. And to the extent that this is a problem, the department would look at ways to incorporate the religious freedom concerns and even potentially to include a clause specifically protecting religious freedom. So we're hoping that the department utilizes 4SA's proposals there about a clause that would expressly prohibit unfair discrimination based on religious conscience and belief, and it's something we will continue to lobby hard for. And although the department didn't give any specific feedback during the meeting, they did request that 4SA send through a summary of our concerns and the amendments we proposed to the bill to remedy some of the religious freedom concerns. And 4SA would specifically like to encourage people to pray for the input that we will be sending into the department, that it would find favor and result in positive changes to this law.
Yeah, I think just to wrap up, my impression of the meeting was that I left with a sense of cautious optimism that our voices had been heard. And again, thank you so much to everybody who made your voices heard. And we've always said, and we continue to say, when the public participation opportunity presents itself, get involved, get engaged, because the more voices, the more engagement, the louder our voice becomes, and the more government has to pay attention to that voice. So the next steps in this, according to the Deputy Minister, was that they're going to go back, they're going to review, they're going to consider the inputs that were made, particularly at the meeting yesterday, and then they're going to send this bill through to Cabinet for Cabinet's approval, and thereafter it will go through to Parliament. So we will watch, we will wait, we will pray, and we will certainly keep you informed of any and every development in this very, very important matter. If you want to see more on this, if you want to know more on this, we have a lot of videos about our original concerns that are on our YouTube channel, but go to our website, forsaforsa.org.za. You can follow us on Facebook, You can also, of course, as I said, go to the YouTube channel, and please do consider partnering with us financially in this fight for faith and freedom. We are 100% dependent upon your contributions to do the work that we do, and we trust that we will continue to stand for faith and freedom in this nation on your behalf. Thank you.
Good day. This is Daniela Ellerbeck, the legal advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.